On this episode of Newt's World, the Employee Rights Act of 2025 is legislation that seeks to strengthen and protect the rights of American workers while ensuring fairness and accountability in the workplace. This bill represents the Republican vision for the American workforce, promoting opportunity, protecting workers' rights and privacy, and creating a strong foundation for innovation and growth. The bill was introduced on Wednesday in the Senate by Senator Tim Scott of South Carolina, with companion legislation introduced in the House by Congressman Rick Allen of Georgia. Here to discuss the Employee Rights Act, I am really pleased to welcome my guest, Vincent Vernuccio, President of the Institute for the American Worker. Vinny, you've said the Employee Rights Act is about empowering workers and improving unions. What's wrong with the current system, and what has changed that makes reform so necessary today?
Well, labor law across the country is incredibly outdated. You are talking about laws that were written in the Industrial Revolution that is essentially created for that 1930s economy. The last time labor law was amended was really in the 50s and the 60s. So the Employee Rights Act is the most comprehensive labor legislation that is pro-worker, is there, like you said, Mr. Speaker, and once again, thank you for having me on, to empower both workers, allow them to work how they want, with who they want, and choose how to support their family. And there's also things that will help improve unions by making them more accountable to those workers.
What actually is wrong with the current system?
There are multiple things. So right now, unions can organize workers without a secret ballot election. You have the labor board, the National Labor Relations Board, that administers union elections and enforces labor law for most private sector workers, that can actually allow an election by secret ballot and then pull the rug out from under workers and say, well, the employer may have done something wrong, so we're just going to toss that election out the window and recognize the union anyway, even if the employees voted against it. From administration to administration, you see different definitions of people that could work for themselves versus an employee. Same thing with small businesses, subcontractors, franchise businesses that work with other businesses. From administration and administration, you see this ping pong of who is considered an employer and who employees actually work for. Happy to get into all of those details. Some of the worst things we saw under the Biden administration, going back to standards that let union organizers and people representing unions actually do just vile harassment of workers and allow them to be protected by labor law. So that's just a smattering of the issues that the Employee Rights Act protects and addresses, as well as protecting the privacy and the political ideals of individual workers. And happy to get into all this. I know it's kind of a smorgasbord of good ideas. Really excited to chat with you about it.
It's fascinating because, as you know, union membership has declined from 20% of workers in 1983 to just about 9.9%, about 10% today. That's a 50% reduction. Why do you think union membership rates have declined, and how does that affect the current workforce?
Well, labor law is severely outdated, and the union business model is mirroring that. You know, if we went back to the 1930s, unions would be in great shape because they have that one-size-fits-all bargaining. They're basically created to have that adversarial relationship with employers. I think they're essentially selling this product that most modern workers do not want. I've done studies on this very issue that show that if unions adapted, they gave up the government-granted crutches. They acted like professional service organizations that were completely voluntary. That if employees wanted to join and get the representation, they could. If employers wanted to use them essentially as an HR arm, they could. And unions could choose to work with who they want if they did that, if they embraced kind of a modern workforce, professional service association model, they could thrive. But unfortunately, with things like the Protecting the Right to Organize Act, with things that unfortunately people like Senator Hawley are advancing in the Senate, like the Faster Labor Contracts Act and some of the other things with his framework that I know we'll probably chat about, they're unfortunately doubling down on the outdated, failed models of the past, and it's preventing them from growing and expanding and contributing to that decline.
If you think back to the great era of union representation and how many people belonged to unions, and about a fifth of the country was in a union at the peak of the 1950s. So the question I've got is, what happened? And yet it happened in the private sector, not the public sector. I mean, as I understand it, union membership among public sector workers was about 32%, basically a third, while among private sector workers, it's dropped to about 6%. So you're about 5 times as likely to have a union membership in a public sector job. What happened and why is there that huge difference?
You're right. It's about a third in the public sector versus around 6%, 5.9% in the private sector. Historically, that is where unions really focus their energy on organizing. Also, you see businesses that have to compete. They have to compete overseas. They have to compete with other states. And they cannot simply say, well, we're just going to raise the price of our products to pay for union agreements. That is a lot different in the public sector. It's not like the government of Chicago can just say, hey, we're going to go down to Tennessee because it's a right to work state. So essentially, they had taxpayers footing the bill. There wasn't that competition. They had that monopoly, and that's why you really saw some of these exorbitant union contracts in the public sector, and you saw an increase. Now, that is not the case today. It is about 32%, but that is down from the high. And as you see things like the Janus versus AFSCME case from several years ago that essentially brought right to work to the entire public sector. And Mr. Speaker, as you know, right to work simply means the union can't get a worker fired for not paying them. You saw workers start leaving those unions in droves, well, whether because they didn't think the union was doing a good job or because you see a lot of public sector unions, especially like the teachers unions, just doubling down on far left politics that some of their membership just simply doesn't agree with.
You have said, and it was an article that you and Representative Rick Allen wrote called How to Empower Workers and Improve Unions. And in that you wrote, Congress also needs to modernize federal law to empower workers and improve labor unions to deliver a 21st century economy that benefits the working class. Why do you think the Employee Rights Act is the best step forward to accomplish this?
Absolutely, because it has many of those provisions that we were just talking about. It protects workers' right to a secret ballot. So there's a process called card check where unions can go. It's an open petition process. It can lead to intimidation. It can lead to coercion. At best, there's just deception there because workers don't hear both sides of what unionization would mean. So the first thing it would do is would protect the secret ballot for workers, let them make an informed, private choice on if they want a union to come in and represent them. It also allows workers to fully opt out of union representation. Right now, even in right-to-work states where unions can't force workers to pay fees to them, even if they're not a member, they're still stuck under the union contract whether they want to be or not. Workers' choice would allow workers to fully opt out, not just of paying the union, but of union representation and act like the almost 90% of the rest of the economy that is not represented by a union. It protects workers' privacy. Right now, unfortunately, if a union petitions an employer, the employer has to give all sorts of personal information to the union, workers' home addresses, personal cell phones, personal email. What the Employee Rights Act would do is it would allow those workers to say, I just want them to have my email. I don't want them to have my home address. And it would prevent the employer from having to give all of that personal information. Now, if an employee wanted the union to have that information and be contacted, they're more than welcome to, but it's not like the current situation where even if the employee doesn't want it, the union is forced to get it. Going to your question on the modernization, it allows legal clarity for independent workers. So right now, from administration to who's an employee is amorphous. The Biden administration wasn't exactly what California did, but essentially they wanted to do what California did, making most people entrepreneurs working for themselves defined as an employee. The Employee Rights Act would take Representative Kevin Kiley's Modern Worker Empowerment Act and make it much easier for people to work for themselves. It would protect small business owners' ability to own a franchise or be a subcontractor without saying that their employees are jointly employed with others. It would make sure that only workers legally authorized to work in the United States are voting for union contracts and for unions to come in. And it would also make sure that unions, which have this duty of fair representation to all employees, are fairly representing all employees and not including DEI in collective bargaining agreements. We talked about the protection from harassing language, which unfortunately, because of the Biden NLRB, was allowed. It would also close a loophole that allows unions to be exempt from RICO statutes. It would also allow workers to have an opt-in as opposed to opt-out in supporting union politics and a few other provisions as well. So I know that's a lot, but once again, that is why the Employee Rights Act is the most comprehensive bill, labor, free market, pro-worker labor legislation of the Congress. And I applaud Representative Allen and now Senator Tim Scott, who just introduced the bill, the companion legislation on the Senate side this Wednesday.
Note, according to Open Secrets, that from 2023 to 2024, public sector union PACs donated $12.5 million to Democrats and $1.6 million to Republicans, although my guess is that the actual votes were much more narrow than that. So you have a lot of money going from Republicans to subsidize Democrats. How does your act affect the compulsory use of my money to support candidates I'm opposed to?
Sure. So let's back up. So the Employee Rights Act changes federal labor law. And federal labor law really only affects workers in the private sector. So we're talking about most private sector workers that aren't working for railroads and airlines. That's the vast majority of the private sector, but that's who the Employee Rights Act protects. Public sector employees are governed by state labor law, and each state has different labor law. But obviously, the public sector labor law, most states base it off of the federal law. So we may see copycat legislation at a state level for things that do affect public employees. But going back to your question, let's just bring it back to the private sector. What the Employee Rights Act does is it has an annual opt-in. So for anything that is not collective bargaining, and this is for right-to-work states, non-right-to-work states, unions have to say, well, we want to spend your money on X politics, and you have to opt into that. And workers get that opportunity on a yearly basis to make the decision whether or not they want to support their union's politics, and if they want that money, if they're given to the union or taken out of their paycheck. So that's one of the great provisions that really puts workers in the driver's seat when it comes to union politics in the Employee Rights Act.
One of the things that surprised me, I think, is that your bill would provide for a secret ballot in union elections. I mean, you sort of think that it's kind of a basic American right to have a secret ballot. To what extent do the union leadership use having an open ballot to control the choices of their members?
So we've done studies on this, and Senator Scott and Representative Allen's bill. Unfortunately, there are example after example of intimidation and coercion. I've testified before Congress on this. As the NLRB said, an overzealous union organizer coming to somebody's house and saying, I'll slash your tires, or, the union knows, come to your house if you don't sign this card. The cards themselves are problematic. You could have in big font, come to this pizza party, sign up here, or enter this raffle, or what have you. And then a little 6-point font on the bottom, I hereby authorize the union to represent me. So unions can actually go to employers, and if they get 50% plus one of those cards, say you must recognize us. And they can also bring all these sorts of intimidation tactics and anti-PR campaigns to pressure employers to give in and recognize the union. So the Employee Rights Act would simply say, we're going to do away with the card check process. And the way that unions would come in and organize is, they would still get the cards. They would petition the NLRB, but then workers would be guaranteed that secret ballot election and would have the time first to make that decision. So it's not just signing a card when somebody presents it in front of you and you don't have time to reflect on what you're doing, but also, just like we vote for president, just like we vote for governor, for Congress, for state legislature, have the ability to vote in a private voting booth without anybody looking over your shoulder. So it is a great step forward in protecting employees' right to choose who represents them.
If unions can come in and basically insist on a public vote, why have they not organized more of the country? I mean, it seems to me it's very heavily rigged in their favor.
You could say it's not exactly a public vote. It's simply a card signed. So there's never actually a vote. And that comes back to that deception of, I just want to sign up for more information or for this pizza party. And then, lo and behold, the union says, well, we're going to use this card to organize you. So, we've seen card check campaigns where workers they don't get enough cards signed. You have good employers that want to say, we want to protect our employees' right to a secret ballot. And this is something that the Protecting the Right to Organize Act, several years ago, the Employee Free Choice Act, and the NLRB is trying to do away with. Now, they're doing away with it in the PRO Act, and what the Biden NLRB did, not in the most obvious way. They still say, hey, you can have an election. And what I would say is they're doing is actually worse, because then once again, they can take the rug out from under those workers and say, even if you have an election, the employer did something wrong. So what we're going to do is we're going to toss out that election and we're going to recognize the union via cards. So it really is insidious. But the Employee Rights Act, that's one of the first key provisions, is stopping that and making sure that employees' right to that private vote is protected.
When you look at your bill, the Employee Rights Act, there was a survey done, and something like an overwhelming majority, I think 67%, supported the right to a supervised secret ballot on deciding whether or not to join a union. Interestingly, 72%, even more, among union households. And when you ask whether employees in right-to-work states who opt out of union representation should be free to negotiate contracts, wages, and working conditions directly with their employee, 68% support it, including 68% in the union households. And it seems to me that your bill has pretty solid national support.
It really does. And the individual provisions in the bill, whether it's the Employee Rights Act individual provisions or the standalone legislation that was used to create this great omnibus legislation, it has vast support. And you just talked about the workers' choice polling, where about 68% of total households and union households support it. This is actually something that the union rank and file have been consistently told is an issue with right to work and why they can't have right to work. So essentially, unions claim what they call the free rider issue. I like to call it the forced rider issue. But essentially, with right to work, we can't force workers to pay us, but they still get the same benefits of the contract. What Workers' Choice does, it says, you don't want to represent workers that are not paying you, unions in right-to-work states where they're not forced to pay, then you don't have to, and workers can represent themselves. So for all the times that they go and they rail against these right-to-work laws, this is giving unions actually exactly what they're asking for. Now, at the end of the day, they would much rather have the monopoly, and they would rather force workers to pay than give up that monopoly. But it's essentially addressing that main issue. And then same thing with the secret ballot. You're seeing 72% support among union households. And the right to privacy and having their private information shared, you see 80% of union households agree. That's even greater than the 76% of households. And when you talk about those independent contractor provisions, those joint employer provisions and others, all of those are in the high 70s, some in the high 60s, or even pushing over 80%. all the provisions of the Employee Rights Act poll extraordinarily well, not just with households, but also with union households.
How much do you think, in that sense, that the union household of today is significantly different, say, from a union household in 1955?
We are seeing differences. Obviously, as you said, there are fewer union households because there are fewer union members. And once again, I think a big reason for that is because unions have that 30s, 40s, 50s business model that does not translate into the flexibility that modern workers want. You are seeing, similar industries, except for, as you pointed out, the growth of the public sector. And there really wasn't public sector bargaining in the 40s. It really wasn't until, the 50s, 60s that first there were federal executive orders and Wisconsin allowing public employees to bargain, and then it really expanded out. So if you're talking about the atypical union household, used to think an auto worker or a truck driver. Now, really, it's a government bureaucrat.
Does this bill apply to the federal employee unions, or should there be a parallel bill to apply to the federal employee unions?
There definitely should. It does not. Once again, this is for workers in the private sector. If you want to get really deep in the weeds, it's under the National Labor Relations Act employees, the NLRA. That is basically everybody but railroad and airline workers. There's other provisions that touch on like the Fair Labor Standards Act and some other legislation. But for the most part, we are talking about workers in the private sector that are not railroad or airline employees.
I'm trying to remember, is the NLRA a 1930s bill originally?
It is. It was amended in 1947 by Taft-Hartley that allowed states to opt into right to work and several other provisions. And then a couple decades later, it was the Labor Management Relation and Disclosure Act, the LMRDA, that brought more transparency to unions.
But in many ways, we're still operating under a system whose structure reflects the industrial behavior of the late 1930s.
You are absolutely correct. Not just the law, but also what the law enables and the union business model. And once again, going back to the issues with why private sector unions and frankly unions in general are declining, it's because their business model is corresponding with that law and is based in the Industrial Revolution, the 1930s, workers working in factories, less skilled, more interchangeable than the modern dynamic workforce of today that wants the flexibility, that wants to be rewarded for how hard they work and wants to be treated as individuals instead of these one-size-fits-all bargaining arrangements.
When you take the individual components of the bill, support goes as high as 81% in union households for some of the provisions. What's the opposition? Why is it going to be hard to move this bill? What's the opposition?
Oh, well, you see most Democrats just saying, well, hey, we'd rather see the PRO Act that is essentially the opposite of most of the provisions of this bill. They have those attacks on the secret ballot where it's not exactly card check, but essentially they can toss out secret ballot elections. It's the making employees across the country similar to what we saw in California with the attacks on independent contracting. They have a different definition of who is an employer and attacks on subcontractors, small business, franchise owners, saying that their employees are actually the employees of a distant corporation. There are other provisions within the PRO Act that are, essentially the opposite of what we're seeing here in the Employee Rights Act and what you see with Democrats and unfortunately with one or two Republican senators like Josh Hawley, that's what they are embracing.
Why do you think people like Hawley, who otherwise would be a pretty normal Republican, but on a couple of these issues, he sort of ends up on the other team? Why do you think that is?
Just on Wednesday, there was a hearing where he invited Teamsters President Sean O'Brien to speak, and they had a back and forth. He has his Faster Labor Contracts Act that would allow government bureaucrats to appoint an arbitration panel that would literally write the first contract between a union and an employer if they didn't come to an agreement in a vastly truncated time period. And this would cut out worker voice that would not have the ability to vote on these contracts. And it could essentially write for the foreseeable future, because subsequent contracts would be based off this first contract, over every aspect of the worker's job site and how they would work. So it is incredibly troubling. And unfortunately, I think Senator Hawley is misguided on that.
Somebody told me one time that there's some amazing percent of workers who work under contracts that date back so far that they never had a chance to vote yes or no. It's just part of the job environment that they sign up for. Is that a significant problem?
So we actually had another study on this. Once again, all of this is on our website, i4aw.org, i4aw.org. And yeah, we crunched those numbers of union elections. And it turns out that, once again, we're talking the private sector here, almost 95% of unionized employees never had the chance to vote on their union. Whether the union was voted generations ago and they were simply handed a union card when they took the job, or whether the union's organized via card check. But putting those two issues together, almost 95% of workers in the private sector that are unionized never had the ability to vote on the union at the workplace. And it's also very similar provisions in the public sector as well. In fact, when I was doing work with the Mackinac Center in Michigan, we crunched these numbers and we found minuscule amounts, in some cases, 0% of employees had the ability to vote. Let's say it's a teachers union in the top 10 school districts in Michigan. I didn't want to just say 0. So then I said, statistically speaking, this was several years ago, how many teachers were even alive when the union organized? And it was less than a third were even alive when the union organized. So you're not even talking about your parents' union. You're talking about your grandparents' union. So workers should have this ability on a periodic basis to vote for the union at their workplace, or at a very minimum. Representative Bob Onder has another bill that's not included in the Employee Rights Act, but that will require at least a quorum of workers to vote for a union in a secret ballot election before they can be organized.
Amazing. Now, if the Employee Rights Act passes, how do you think it'll change the relationship between workers, employers, and unions over the next decade?
I think it would improve it. Once again, it would have unions representing workers that voted for them, that weren't either pressured in via card check or allowed to be organized after a no vote and the unions came in. It would make unions more responsive to their workers' political leanings, as opposed to just taking them for granted and really not giving workers a say in how a union spend money on politics. It would make unions represent all workers, as opposed to including DEI provisions in collective bargaining agreements. It would increase decorum in work sites by making sure unions aren't able to exploit a loophole that allows them to have just really vile harassment, racial, sexual harassment of their colleagues. But as long as it's in furtherance of a union objective, the National Labor Relations Board says it's okay. It would also make sure unions aren't exploiting the other loophole to the RICO statute and allowing union violence in the furtherance of those union objectives. So it would increase decorum, it would increase worker voice, it would increase worker safety, as well as making sure that unions are representing all workers equally.
Those would be enormous changes, but I'm curious because I know how busy you are and how wide-ranging you are. What other things are you beginning to work on in terms of reforms that you think are needed?
Oh, we just talked about Representative Onder's bill. That is the Worker Enfranchisement Act that would require a quorum of workers to vote before a union can organize. Representative Owens has the SALT Act. One way that unions organize is by having union organizers literally lie to employers saying they want to work for them, but they're really just taking a job to organize the workers, in some cases, not even tell their coworkers that they're a union organizer. As we've seen some Starbucks workers say, they feel like they were duped into the union because they didn't realize this was actually a union organizer, making sure they're disclosed. So if a company hires someone to talk to employees for or against unionization, that has to be disclosed to the Department of Labor. So should a union hiring someone to get a job and talk to employees. It's simply parity. And that's Representative Owen's SALT Act. The Trump administration on the regulatory agenda says that they will be addressing the independent contractor issue. We hope we see something very similar to the first Trump administration's definition of who is an employee and allowing workers that to work for themselves if they satisfy what was deemed the entrepreneurial opportunity test. Similar to the provisions of the Employee Rights Act, we're seeing those joint employer regulations on the long-term agenda that hopefully will come down either from the Department of Labor or when the National Labor Relations Board has a quorum when the Senate votes to confirm President Trump's nominees. So those are just a few examples of what we're looking at for the private sector. And then that's not even getting into some of the federal employee issues that we're looking at both in Congress and through the administration.
I have to say that the Institute for the American Worker is doing very important work, and that we're very grateful for your leadership and your willingness to do all this. So I want you to know that we're going to continue to pay attention, and hopefully you'll come back and brief us as things develop. I really appreciate you taking the time to be with us and the fact that we have a chance to stay in touch. And our listeners can find out more about what you do at the Institute for the American Worker by visiting your website at i4aw.org, which we'll also have on our show page. So thank you, Vinny, very much for being with us.
Mr. Speaker, thank you as always for having me on. Look forward to being on again.
Thank you to my guest, Vincent Fernuccio. You can learn more about the Institute for the American Worker on our show page at newsworld.com. Newsworld is produced by Gingrich 360 and iHeartMedia. Our executive producer is Garnsey Sloan. Our researcher is Rachel Peterson. The artwork for the show was created by Steve Pendley. Special thanks to the team at Gingrich 360. If you've been enjoying Newsworld, I hope you'll go to Apple Podcast and both rate us with 5 stars and give us a review so others can learn what it's all about. Right now, listeners of Newsworld can sign up for my 3 free weekly columns at Gingrich360.com/newsletter. I'm Newt Gingrich. This is Newsworld.